like you to meet Jennifer Bishop-Jenkins. She's director, Marsy's Law for Illinois, here in the studio with us. How are you?
Good morning. I'm great.
Thanks for taking the time to come in.
Thank you for having us, and we're going to be talking about the Crime Victims' Bill of Rights, which is on the ballot in Illinois this fall.
Give us a thumbnail on this one for people who are not aware of what we're talking about here.
So it's a victims' rights constitutional amendment. We need to amend the Illinois Constitution to fix a couple of problems that crime victims experience in their access to the criminal justice system. We actually have a current victims' rights amendment that was passed in 1992. It actually has some flaws in it that have to be fixed constitutionally. There's no other way to correct the problem. And they have to do with the right of a victim to actually talk to the court to enforce their rights if there's a violation of their rights. And while many victims' rights are respected, quite often they are not, because right now what we have basically is voluntary compliance. And if the courts or the law enforcement officials or the defense attorneys or whoever happens to just want to ignore them, they will. And so we want to fix that by giving the victims themselves the actual right to talk to the court, to ask the court to enforce their rights. And that's what this will do.
In short, in enforcement mechanisms for the laws that are already on the books.
Right. It's an enforcement mechanism. And it gives victims an explicit standing in the court so that they could actually file a motion. For example, in the case of my family, my sister, her husband, and their baby were murdered in suburban Chicago in 1990. And we were trying to actually, we followed through cooperatively with the entire trial of the killer. He was sentenced to mandatory life without parole because it was a triple homicide. But because it was a mandatory sentence, they actually denied us the right to make our victim impact statements. And that was, at the time, we were just going along with what we were told. But honestly, in hindsight, that was a real violation for us. We wanted to be able to make that statement in court to the killer, to have him hear that and to have that in the court record. And for us to not be able to even ask the court, please, can we make this statement, even though under law at that time we were already entitled to make it.
Not ask for permission, but you were entitled to make it.
We were entitled to make it, but we were told, nah, it's a mandatory sentence. We're just not going to bother with that. We're not going to take the time to do that.
It's not a bother for you, though.
It was not. And it would have been actually important because even now, 24 years later, he is still trying to appeal his sentence, and there's a court battle going on. And it would be good to have that statement in the record of the impact that it had.
Because then a review
crimes.
board can look back at the impact statement and act accordingly.
It's actually an important part of the case to have the victim's perspective. So it's and my case is just one of many much more serious violations where, for example, rape victims, their diaries are being subpoenaed by defense attorneys because they want to besmirch their past, even though the diary contains no evidence whatsoever with regards to the crime. And right now, there's no grounds under which the victim can object. So this would change all that.
Jennifer Bishop-Jenkins with us, director of Marsy's Law for Illinois. More info at marsyslawforillinois.org. Again, this is be on the ballot in November. Why is it that it's only able to be done this particular way?
Because it is in the current Illinois Constitution that victims cannot appeal to the court a violation of their rights. And Illinois is actually now the only state in the nation that has that, what we call appellate bar. That means that they can't fix the problem after it's been done to them in the course of the case. For example, they weren't notified in time to come to a hearing, or they weren't allowed to ask for restitution, or they weren't allowed to bring a support person of their choice. They don't have rights in the case. They don't have any rights on the matters pertaining to defense and prosecution. But with regards to their own participation in the case, we have to give victims the ability to ask the court directly to repair violations of their rights. So we have a constitutional bar. We're the only state in the nation that still has that language saying victims can't appeal in the post-conviction world. Actually, Oregon had it, but in 2008 they fixed theirs, so we have to fix ours too. We have to get rid of that.
There are many non-binding matters in the ballot this fall. This one is binding.
Very much binding.
It counts. Is it a simple 50 plus 1, or is it at 67 2/3?
It's a simple 50 plus 1 for everyone who picks up a ballot. And then if people were, unfortunately, to drop off before they reach the end, it's a 60% of those who actually vote on the question.
Okay. So, and that is an issue, especially this year. It could be because the ballot's going to be lengthy and there will be multiple.
It is.
So if you don't vote either way on this question, it counts
could hurt
as
us.
it could hurt the effort. Absolutely. Right.
Yes,
okay.
it could really hurt us. And so it's really important that people go to the bottom of the ballot and find that Crime Victims' Bill of Rights constitutional amendment and vote yes.
Yeah, slog through everything else, but
Right.
make sure that you're looking for that.
That's right.
Give us the origin for people who don't know of why it's called Marsy's Law.
So Marsy Nicholas was a murder victim in California. Her boyfriend shot and killed her. Horrible shotgun to the face. She was actually breaking up with him, and he killed her because she was breaking up with him. And when he was arrested, the family was notified. Was not notified. Actually, they were at the grave burying her. Coming home to their home after they literally had the dirt of the grave on their hands. When they stop by the grocery store to pick up some groceries, and they see the killer in the grocery store confronting them. They called the police. How come this guy is out and we weren't told? And the California police said, we are under no obligation to notify victims' families of the release of the offender. And that's when the Nicholas family said, well, we'll see what we can do about that.
We're going to see about an obligation.
And they have changed, and they made California's constitutional amendment for victims' rights, Marsy's Law, the strongest protections for crime victims in the country. And they want to share that with the nation. And so that's a national movement that we hope ends up amending the U.S. Constitution at some point in the future, putting crime victims' protections in the U.S. Constitution. And, the important thing is that here in Illinois, we will be adding not only those repairs of the victim right to talk to the court, we're going to add 2 new rights in the Constitution. As long as we're going to amend the Constitution, we want to take this opportunity to make victim notice upon the release of the offender an actual constitutional right.
Yeah. I mean, of all, right off the bat, hey,
Yeah.
Somebody's out and it will affect your life, as it did there.
So that will be added, and I hope everyone will vote yes on that.
Jennifer Bishop-Jenkins with us. She's the director of Marsy's Law for Illinois. Marsy's Law for Illinois.org is the website. It's Riley and Scott on WROK. Bipartisan push here. It was unanimous in the Senate. There were 2 no votes in the House among the 100 and whatever members down there. Mm-hmm. What are the objections? I think defense lawyers have a problem with it.
Yes, exactly. The 2 no votes were reflecting concerns of defense attorneys who defend the accused and the offenders, and were. It's, I think, a real misunderstanding that there's some sort of a zero-sum game, that if you have more rights for crime victims, somehow that hurts the rights of the accused. But actually, victim rights and the rights of the accused are completely parallel, non-intersecting. The rights, their rules of evidence and all of the rights that they get in the course of their presumption of innocence, all of that is protected. There's no
there's no encumbrance by what you're asking
Just because a victim has a right to make a statement at sentencing, or has a right to attend the hearings, has a right to consult with the prosecutors, bring a support person, ask for restitution, none of those things interfere with the rights of the accused. So I think those few folks that do object because they're afraid that somehow stronger victim protections will hurt the accused, I think they're wrong about that. They're just wrong.
This is the first time that it will appear on the ballot, the first push to get this changed in Illinois?
That's right. This is the first time we've had a chance to do anything constitutional for crime victims in decades. And so this is a great opportunity to really reform the system to make it. And, potentially every single person in Illinois is a crime victim. This is one of the most universal issues. Other special interest rights votes only affect certain populations. This one is universal. Potentially every single person is a crime victim, and quite often may have to intersect with the system. So this protects everyone in terms of their ability to make sure that they can talk directly to the court about their own fair treatment after a crime.
I'm going back to what you were talking about with California, too. Well, we have no obligation to let you know. Other than maybe being a human being, you would think. You would think that somewhere along the bureaucracy, somebody would have thought, do we need to be forced into doing the right thing here, or should we just make this part and parcel of what we do? Obviously, based upon the amount of work that you're putting into it, they have to be forced into it.
I think it's often just a lack of resources. There are so many phone calls that you have to make and factors to consider, and sometimes folks are just so busy in the courts that they just don't take the time to do this. But what we have found actually in other states, for example, California, what we have found is that having this enforceable right on the ballot actually puts everybody on notice, and it makes them very preventative. We actually have seen earlier attention in the courts now in California to checklists from the bench, from the judges, saying, have you done this? Check this off. Has the victim been notified? Is the victim signed off on this plea bargain? Is the release of the offender, have they been notified? And it's forcing earlier communication with victims, which is actually, they say, saving time, money, effort, agony, and preventing mistakes. So by having the victim better engaged earlier in the case, by requiring the victim to be contacted and talked to, which right now is just sort of a luxury, it happens sometimes but not all the time, is going to really help the system to work better for everybody.
Jennifer Bishop-Jenkins with us, Director Marsy's Law for Illinois. Let's make sure people know again where it is. It's on the ballot in November. It's going to be way at the end.
Right.
So make sure you get through to it.
And it's going to be called the Crime Victims Bill of Rights.
And that's what it will say on the top of that question.
Right.
And to be clear, too, because sometimes they trick us this way. Voting yes means you want it.
Yes.
Okay.
That's right.
Sometimes they're tricky that way.
Yeah, that's true, and especially you're dealing with the double whammy of being at the very bottom of the ballot as well.
Right.
I've got so much eye fatigue from what I've gone through thus far, but make sure you keep that in mind, and the yes vote is what you're looking for.
It is worth skipping through all of the other stuff just to get to this, because this is important. Thank you.
For people who want to root around and find some more information, look into this a little bit more, maybe join you in advocacy and all that.
Yes.
Where should they go? What should they do?
Marsy'sLawForIllinois.org, and that website is Marsys, Marsy's Law for Illinois.org spelled out. So
Okay.
yes.
And I got it popped up here on the screen, too. You got frequently asked questions, so you can get right up to speed on all of these things and why a constitutional amendment is necessary.
Did we hit most of those? Did we get them all?
I think we did. I didn't follow the questions while we were doing it.
Right,
We just
good.
kind of did our own thing for once. But yeah, I think it's all right there. And is there any other resource that people should look at, or is that the number one source?
IllinoisVictims.org and all of the large infrastructural victim support agencies like the Illinois Coalition Against Sexual Assault, ICASA.org, the Illinois Coalition Against Domestic Violence, ILCADV.org, all have great information about it.
All right. Thanks for taking time to come in.
Thank you.
We really appreciate it.